And there you go, Judge Deborah Nelson saying that will not come in. Let's bring in our guests. Back with us, attorney and legal correspondent for us here at HLN, Gene Casares, and joining us as well, attorney Marc Lyons. Marc, your thoughts on that? Could those, any allegations concerning Trayvon Martin and marijuana use or some of the, and they're probably different issues, by the way, but I think a lot of our viewers want an overall scope. How could that come in? What would the state have to do to open the door for some of that to come in?
I think the big issue here is, one, marijuana use, as we all know commonly, it can be in your system for up to 30 days. And the state has taken the position that there's no way that any expert can tell whether, in fact, Trayvon ingested that on the night in which this event occurred. The defense has taken the position that George has said on the 911 tape after seeing Trayvon that he appeared to be under the influence, and certainly that is relevant as it relates to the interaction between the two, the actions of Trayvon that evening, and the suspicion that it raised in Mr. Zimmerman's mind. I don't think that that information is ever going to see the light of day in the courtroom, however, unless the state opens the door to suggest that he was acting in normal conformity with normal public behavior, and I don't think the state, knowing what we know now about the judge's instructions, will do that.
Gene, Trayvon Martin family attorney Ben Crump talking there, and the key thing he said there, Trayvon Martin is not on trial. He's hinting at some of the allegations, some of the things that became public from the defense, and let me just read over them again, and this is what the judge ruled on. The jury will not hear of Trayvon Martin's alleged marijuana use, no mention of any alleged prior fighting incidents, no mention that Trayvon Martin allegedly was familiar with guns, and no mention of Trayvon Martin's toxicology report or the level of THC at the time of death. Marc Lyons back with us, criminal defense attorney. Marc, again, how important is this? Let's go grand scope first, and then we'll get specific with some of these. But how important is this? How big a blow is this for the defense?
I've been watching some of the coverage today, and I have to tell you, I'm somewhat surprised that the position unanimously has been that this has been an overwhelming victory for the prosecution. People in the legal community, specifically those who practice criminal defense, would tell you that this is not a surprise. I think, in actuality, this was a victory for the defense. And I say that because you have two courts competing at this moment. You've got the court of law, and then you have the court of public opinion. The court of public opinion now has been made aware of text messages regarding prior acts of violence. You've got a picture of him with a firearm. You've got indications that he was smoking marijuana regarding the information in the toxicology report. That information is as valuable as information that will be presented to the court as a result of the fact that everybody in the community, everybody in the media is now talking about it. And that information is going to be critical when jury selection comes and these jurors are picked to determine the guilt or innocence, or the guilt and innocence of Mr. Zimmerman. And I have to tell you, I think it's a victory for the defense.
Again, with your bottom line take is that a potential juror could have seen that. Whether or not it comes into court, a juror out there in the community could have seen it. That's what you're saying.
What I'm saying is that the defense attorney certainly had every right to legally bring this before the court and say, I think this information is relevant and should be introduced. We all know in the defense community that that was unlikely to occur. However, she did leave open the fact that information regarding Trayvon's reputation for violence is admissible, however. So I don't fault Mr. O'Mara for bringing that to the court's attention, trying to get that information in, because at best what it does is get out in the community the fact that Trayvon has been smoking marijuana, handling firearms, had discussions regarding previous fights. All of this information had not been previously disclosed, and the picture of Trayvon was painted quite differently by the Mr. Crump, the attorney, and the media early on in this particular matter. So round one goes to the state and Mr. Crump regarding damaging information regarding Mr. Zimmerman and his past. Round two goes to the defense.
Okay, that according to Marc Lyons, and Marc Lyons back with us. Marc, help clarify for us. It sounds like he's laying out that was preemptive, that we have to introduce some of these things concerning Trayvon Martin just in case the state goes places in their trial, then we have this at our disposal, right? And where would the state go that would open the door for some of these things? Would the state have to talk about George Zimmerman's character or past behavior? Then you can talk about Trayvon Martin's? Is that what would happen?
I think what's important here is that there's a discovery obligation, meaning witness identification, physical evidence, tangible evidence, impeachment evidence, the state has a duty to disclose all information that they have to the defense. The defense also has a reciprocal duty to then furnish to the state information that they believe they may or may not use at trial so as not to surprise anyone. And that's exactly what Mr. O'Mara did. What he's effectively saying to the state is, if you introduce evidence that would suggest that Mr. Zimmerman was the aggressor, that this information regarding his drug use and the fact that that may have played some role in his actions that evening may become relevant, in addition to the fact of the picture with him with the firearm and the propensity for violence that he suggested. So I think what this ruling here today has done is that the state...
Mark, forgive me for interrupting. We've got to hit a hard break. We'll be back with more. We're going to be covering this throughout the afternoon. And so, again, the jury. Hey, Marc Lyons with us real quick. You think that jury's going to end up being sequestered, Mark?
I absolutely think they are going to be sequestered. I think the judge has in her discretion to do that. I think in this case, in light of the media coverage, the sensitivity and the gravity of the charges, I think it'd be a mistake if she didn't do that, and I think she will do that.
Okay. And to sequester the entire jury pool, you know, that's asking a little much, isn't it, as far as logistics?
Well, I would only ask that if she did change her ruling and decide to do that, she use my Amex so I can get the points, because I got to tell you, 500 people using my Amex, I could get a couple of free vacations out of that one.
Got it. And another ruling concerning the jury. The defense wanted to take the jury on a field trip, basically, to where the killing took place. That's not going to happen. A couple of reasons from the judge. Again, with the logistics, basically, Judge Nell said it would be a logistical nightmare, and also it might affect or get the identities of the jurors out there as well. We don't want that either. We're going to... Thanks again. You're watching HLN News Now. Michael Lyons there. You're hearing from George Zimmerman's attorney, Marc O'Mara, talking about the anonymity of this jury, that it needs to remain anonymous so George Zimmerman can get a fair trial, one of the many discussion points today in hearings. Again, this trial set for June 10th. The judge made that ruling. No delays, defense. The judge wanted to delay the case. We are starting June 10th. Made that ruling long ago. We're sticking to it. Marc Lyons is with us, criminal defense attorney. All right, Mark, let's talk about, you know, the social pressures there hinted at by Marc O'Mara. What about that? Do you think there's any real argument on whether or not this jury should remain anonymous?
I think absolutely that the jury should become and remain anonymous. There is immense pressure on both sides of this particular fence, whichever side you are lying with before the evidence is heard. We have the camp that obviously is pro-George Zimmerman. You obviously have a camp that's pro-Trayvon Martin. There will be, if the jury is not anonymous, immense pressure on these people from the community in which they live to vote a certain way. And if those individuals' identity is exposed, that could potentially sway their vote and then subject them to harm. And I don't think that in this particular case, when you're talking about the state asking to put this man away for life, that should be something that a juror should be in fear of when they're sitting on that panel.
You know, one of the rulings that went against the defense, that the defense wanted, you know, for lack of a better term, a field trip for this jury so they could go basically to the place where the killing took place, and the defense said that would have helped with context. Didn't happen. Judge said no. Logistical nightmare, and it might affect, again, the anonymity of the jury. Is that a big loss in your eyes, Mark? And how would the defense potentially have gained in that?
I'm a little surprised that the judge didn't allow them to have this opportunity to go see the scene. As we know in Mr. Zimmerman's interview with Shepard Smith, that the details about where they were positioned ultimately, from the first contact to where the fight began to where his head was getting bashed allegedly into the concrete, that's become a very critical issue in the particular matter. I'm surprised that the judge made the decision not to do that. I understand there may be logistical considerations, but the man is facing life in prison. I think that outweighs the logistical nightmare. However, there are alternatives for the defense. They could obviously video the area if Mr. Zimmerman testifies and can lay the proper foundation for that. I think ultimately that will be almost as effective as going to the scene.
You know, one of the hearings that what's now going to become a Fry hearing, talking about voice identification experts. Will they be in? Will they not be in? I mean, when you talk about some of the terminology, that could really decide the case. That could be huge, right? Whether or not some expert could say that is Trayvon Martin's voice and he's pleading for his life, or that's George Zimmerman's voice and he's asking for help.
Let me just tell you something. I could find an expert that will make an opinion or render an opinion that people who wear bow ties are more trustworthy than people who don't. Now, that issue we know is ridiculous. And I don't think that, I think the state or the prosecutors will be making a mistake if they overcomplicate the issue of voice identification. Have people in the community that knew Trayvon, can recognize his voice, come in, have an opportunity to listen to the 911 tape and say, there's no question that that's Trayvon Martin. Don't overcomplicate this, because the defense will find somebody, and they have found somebody, who will say that this is inconclusive. I think that the voice was Mr. Zimmerman, not Trayvon. And now what you have is a jury in the back saying we have these competing expert opinions as to whose voice it is. Let's throw it out altogether, because we can't make a conclusion based on the differing opinions of experts.
So how, Marc Lyons, how does this conversation, this back and forth get into the case where a jury would hear them go back and forth?
The jurors will not have an opportunity to hear it go back and forth. More likely than not, this will come up when George Zimmerman takes the stand. If he takes the stand and suggests that when he witnessed Trayvon walking that evening, he appeared to be under the influence of alcohol, that obviously then affected him in the way in which they interacted with each other later on, and his aggressive behavior may have been attributed to this ingestion of cannabis. I think at that point it may be then up to the judge to determine what, if any, questions, if the prosecutor on cross-examination opens the door and starts asking questions about the truth and veracity of some of those statements that he's suggesting about the way in which he looked. Did it look like he was on marijuana? Did it look like he was on some type of other narcotic? It may then come in at that point. I still find it somewhat unlikely, although there certainly is a possibility that exists that it may come out.
Yeah, we heard the judge say no previous marijuana use will be in this case. The battle could continue. Gene, Mark, thanks again. Let's bring back home defense attorney Marc Lyons. Before we get into the experts, how many times do you think the jury will hear these 911 calls, Mark, as they try and decide this case?
They'll initially hear it during the presentation by the prosecutor, who will go first in the case. But ultimately, they'll have an opportunity to review and listen to all the evidence when they're back deliberating in this case. They can listen to it as many times as they want. It will be made available for them. They'll be back there to be able to determine themselves, if they can tell, whose voice it is.
Okay, now let's get to the experts. A Fry hearing. And tell us what that is. For anybody who's not a lawyer out there, does not follow the legal game that closely, what's a Fry hearing? What'll be decided June 6th and 7th with concerning voice identification here, Mark?
A Fry hearing is a hearing in which there's an evidentiary hearing. The court will hear testimony from an expert witness, and then there'll be direct examination, cross-examination by the defense in this case, or the prosecution, depending on whose expert is up there testifying. And ultimately, the court needs to decide, is this opinion that this expert is rendering one that's based on sound scientific evidence? If she believes that it's based on sound scientific evidence and it's an issue that is outside of the scope of an ordinary juror to conclude themselves, then this expert testimony may be relevant to help them determine an issue or fact in the case.
Okay. Now, from what we know, the FBI could not identify who is yelling for help. The state, they say they have an expert ready to go to say it's Trayvon Martin's voice. We believe the defense will have someone that'll say it's George Zimmerman asking for help. I mean, how tough of a ruling is this going to, with all that said, will this be for the judge?
I think that the decision for the judge is ultimately going to be based on, one, how do these witnesses, how do the experts, how do they present themselves? How many times have they been tendered as experts in other jurisdictions, whether it's federal court or state court or otherwise? But I'd like to make this point. I think it was a mistake for the state to continue to rely upon this scientific evidence regarding trying to determine whose voice it was on there. There's already been statements made by Trayvon's family, also the Zimmerman's family, about whose voice it was. Don't overcomplicate this case. Play it simple, play it stupid, play the tape, let the jurors make their own conclusions, let them hear the witnesses when they testify up there about people who knew them individually, and let it be at that. Because there will be competing testimony from both experts saying, nope, it's Mr. Zimmerman, nope, it's Trayvon, and that is going to confuse the jury.
Got it. So, but let me follow up on that, because I'm sure people think, but if you really think you got the expert that can say that's Trayvon Martin's voice, why not go for it? Because that could be huge if a juror were to believe that.
Why not go for it? Well, the minute I see you as a defense attorney present an expert who's going to suggest that it was Trayvon Martin's voice there on the 911 tape, as a defense attorney, I'm going to go out and I'm going to find a defense attorney who's going to be equally as effective to you, and they're going to say the exact opposite. And what that does is, by presenting expert testimony, you're then telling the jurors that this issue is one that is so complicated that I need an expert to make a decision as to whose voice it is.
Got it.
And once you tell a juror, hey, this is too complicated for you,
hey,
I need to have a juror do
Mark,
it. I need to have an expert do it.
Got to cut you short. More coming up.
No
Stay
problem.
with us. Now, back with us, criminal defense attorney Marc Lyons. Hey, Mark, I want to pick up on something that Mark O'Mara said, talking about how both sides need to be cautious in how they try the case, and that was evident from today's hearing. What'd you make of that statement? What do you think he means by that, to be cautious moving forward?
I think anybody who watched today's hearing could see that the court was making it very known to both sides that you better abide by my instructions, and when I say something, I mean it. There's not going to be a lot of leniency from the court with respect to either the state or the defense crossing that line or that boundary that she has set. And I think that that's an overriding issue that she's trying to set in example before this trial starts so as to potentially eliminate any issues of a mistrial or any appellate issues.
Yeah, and she was not going to budge on the trial start date. Okay. So Marc Lyons, again, the door's cracked there. If the state does, as Mark James said, if the door opens up at all, then some of this could come in. But what Mark O'Mara said was that they want to really, everybody wants to focus on the 6 or 7 minutes where this all went down. So this could be a short trial if they just do that. Am I right?
It could be a short trial. I don't think it's going to be. I think ultimately the court's going to rule that some of this expert testimony regarding the 911 tape is going to come in, and that may then, obviously, unfortunately, bore a lot of jurors and kind of be a situation where it's ultimately going to delay the trial longer than what it should be ordinarily. If this were a case where there were no cameras or otherwise, this case at most would take probably 5 to 7 days. Unfortunately for Mr. Zimmerman, this case may take longer than that.
Got it. Okay, guys, thanks again. Hey, Mark, what about that? You heard there's a viewer with just a good, honest take here, and I'm sure a lot of people thinking, wait a minute, when does this become character assassination, and when could it be relevant? Help us out with that, Mark.
I think that's an important issue, and I'm sure there's a lot of people in the community that feel that way. However, what the defense attorney is doing is obviously zealously advocating for his client. You have a situation where he's clearly said, if this case is tried on the 6 minutes between the interaction between the two, that evidence isn't going to come out. However, if the state tries to portray Trayvon in a way in which he is peaceful, he is an individual who is otherwise law-abiding, doesn't smoke marijuana or otherwise, if that becomes relevant, then the defense is saying, well, now you've opened the door. There's information that exists that would be contrary to what that position is, and he has every right to zealously advocate for his client who's facing life in prison.
And Mark, real quick, that's where the experts come in, right? It sounds like Mark O'Mara is ready to say there is research that can say or that can show that marijuana can cause some more aggressive behavior, right?
I think where he is going with that is that in the event that there is some type of withdrawal from the THC that's in his system or the cannabis that's in his system, that may somehow make him more likely to engage in physical altercations or otherwise. That's yet to be seen. I think we'll have to tune into it for a later time on that. I mean, fundamentally, people who smoke marijuana, I mean, you don't typically see them going out and engaging in brutality and other acts like that, and I would agree with the caller. However, I would be interested to see exactly what the expert is that he has and what exactly he says.
Okay. Hey, Mark, thanks again.